Welcome to the high-stakes arena of commercial truck accident liability, where the intersection of law and safety determines the fate of multi-million-dollar claims. When a commercial vehicle weighing 8,000 pounds crashes into a car, the legal aftermath is rarely a simple insurance exchange. Instead, it becomes a deep dive into the Federal Motor Carrier Safety Regulations, which is a massive set of rules designed to keep the public safe from the dangers of the trucking industry. Understanding these regulations is essential because they establish the standard of care that every trucking company and driver must follow. If a regulation is broken, it can serve as a powerful tool to prove negligence in a court of law. Today, we are going to peel back the layers of these federal rules and explore how they define liability in a trucking accident case. At the heart of every trucking lawsuit is Title 49 of the Code of Federal Regulations, which contains the FMECA mandates. These rules apply to almost all commercial motor vehicles operating in interstate commerce. The reason these laws are so detailed is that a truck is essentially a massive kinetic weapon on the road. One of the most critical sections is Part 391, which covers the qualifications of drivers. Trucking companies cannot simply hire anyone with a commercial driver license. They are required to conduct extensive background checks and maintain a driver qualification file that includes 3 years of employment history and a motor vehicle record check from every state the driver held a license in. If a company hires a driver with a history of reckless behavior or failing drug tests, they can be held liable for negligent hiring. This is a form of direct liability for the carrier that goes beyond the simple mistakes made by the driver behind the wheel. Another cornerstone of trucking safety is Part 395, which regulates the hours of service. Driver fatigue is one of the leading causes of devastating highway accidents. To combat this, the law strictly limits how long a driver can be on duty and how many hours they can spend driving. In 2026, almost every commercial truck is equipped with an electronic logging device, or ELD, which records the movement of the vehicle in real time. These devices are the smoking gun in many accident cases. If an attorney can prove that a driver was pushed past their legal limits or that the company encouraged them to falsify their logs, liability shifts from a simple accident to a willful violation of federal safety standards. This often opens the door for punitive damages, which are designed to punish the company for putting profits over human life. Maintenance and inspections are governed by Part 396, and they are just as important as the driver's behavior. A trucking company has a non-delegable duty to ensure that their vehicles are in safe operating condition. This means they must conduct systematic inspections and repair any defects immediately. Every driver is required to perform a pre-trip and post-trip inspection to catch issues like worn brake pads or bowling tires. When an accident is caused by mechanical failure, investigators will comb through months of maintenance logs to see if a repair was fit. If a truck has a brake failure and the logs show that the company ignored a technician's warning weeks prior, the carrier is in a very difficult legal position. The law does not allow companies to blame a third-party mechanic because the ultimate responsibility for the truck's safety always rests with the motor carrier. In the digital age, the electronic control module, or the black box of the truck, has become the ultimate witness. This device records the speed and braking and engine status at the moment of impact. Comparing this data to the driver's statements can expose lies and clarify exactly what happened in the seconds leading up to a crash. Beyond the black box, lawyers now look at telematics and tracking and inward-facing cameras. These technologies provide a play-by-play of the driver's actions and show if they were distracted by a phone or if they failed to react to a hazard in the road. In 2026, The use of artificial intelligence in these cameras can even detect if a driver is showing signs of microsleep or impairment. If a carrier had access to this technology and ignored the alerts, they could face severe liability for failing to supervise their employee. Liability in these cases often extends to a whole chain of entities. This includes the motor carrier and the owner of the trailer and the shipping company and sometimes even the broker who arranged the load. Under the doctrine of responding superior, an employer is generally responsible for the actions of their employees while they are on the job. However, many trucking companies try to avoid this by labeling their drivers as independent contractors. Federal law has largely closed this loophole by establishing that for the purpose of safety and liability, the motor carrier is responsible for any driver operating under their authority, regardless of their employment status. This ensures that victims have a clear path to compensation from the entity that actually holds the insurance policy. Speaking of insurance, the federal government requires commercial trucks to carry much higher limits than passenger vehicles. The minimum for most general freight is $750,000, but for hazardous materials, it can go as high as $5 million. In reality, most major trucking companies carry $10 million or more in total coverage through umbrella policies. These high limits are necessary because the medical bills and long-term care needs for a truck accident victim can easily exceed millions of dollars. The presence of these large policies makes litigation intense, as insurance companies will spend vast resources to defend the claim and minimize their payout. The concept of negligent entrustment is another vital part of the legal framework. This occurs when a carrier allows a driver to operate a truck despite knowing that the driver is incompetent or dangerous. For example, if a driver has a medical condition that should have disqualified them under Part 391, but the company ignored the medical examiner's notes, they have negligently entrusted that driver with the vehicle. This is why the medical certification process is so strictly regulated. Drivers must pass a physical exam every 2 years and sometimes every few months if they have underlying health issues like high blood pressure or sleep apnea. A failure in this process is a direct breach of the federal motor carrier safety regulations. Loading and securing the cargo is regulated by Part 393. If a trailer is overloaded or the weight is not distributed properly, it can lead to a rollover or a jackknife accident. Shippers can be held liable if they provided an unsafe load that the driver could not reasonably